We pray God for the people who are going to watch this video later. Let this video to be of help. Them to subscribe to my YouTube channel. The views in purchases. I pray for purchases in my website. And these people to be able to be helped by this content. I pray God that this Zoom meeting will be seamless. There will be no issues with the laptop, with the Zoom itself, and I hope to conduct a good class. We pray all this believing in Jesus Christ, our Lord and Savior. Amen.
Amen.
Sawa sawa. So this is Probate, October 2022. This subject was done, and it was the third field subject. The results they were released in 16 December 2022, last year, 16 December. Out of about 1,500 students, only 40% passed. So it is very, very important we go through it. For you to pass in probate, you need the following. You need the law of succession, Musioka book, the yellow one, very, very important. Angawa book, which color is this book? Gray one, the revised edition. I'll be referring to it very much. Then you need case law. There are many case law online. You need to know the Law of Succession Act, the probate rules, the principles and procedures, how to do a certain thing that you have been asked, the procedure, the drafting, and the case law. This is what we'll be tackling in every question, whether it has been asked or it has not been asked. We also look at possible questions that can come related to the question that have been asked. We also look at the question that was done by the highest scoring student. We critique, especially where she did not score good marks. We see why she did not do, he or she did not do well. And the purpose of this, then from there we can build good answers, better answers. So welcome. And now I'm going to read the first question. As follows. Mr. Wesley, a senior counsel and astute businessman. This is question 1, October 2022. Mr. Wesley, a senior counsel and astute businessman, owned properties which included large tracts of land and houses in various parts of Kenya. He also owned a house in Bold Street, London, UK. So in terms of probate, if you are doing this exam, you underline there is a possible question that is very, very important on when someone is owning property outside Kenya, which he frequently uses as holiday home. He had 3 wives and 11 children. You underline that. That's it's a polygamous person. That's how you do and you write there polygamous. It is going to help you. And at age 75, he started a relationship with Maggie, a marketing executive. He met at the business. The relationship thrived 2 years down the line. Maggie conceived So there is another issue there of an antitrust union or cohabitation. Then she conceived children born out of wedlock. These are questions that you can be asked. She found Mr. Wesley so irritated and told her he would marry her. He then began making plans for traditional wedding, but before the same could materialize, he suffered a head injury while playing golf and rushed to the hospital while unconscious. He remained in a coma for 2 weeks, and when he came out of the coma, he could not remember much. So there is an issue of knowledge and the mental state of a person when he's making a will. So these are things you can see before, even before you see a question. He could not remember he remained in a coma for 2 weeks. When he came out, he could not remember much. His first wife was in his room, and when he regained consciousness, but he could not remember her at all. His children would visit, but could not remember them except a few lucid moments where he could recall some people. The doctor said it was dementia, and its mental state was not so stable. The doctors indicated he could need surgery to remove a cloud from his head. After a month in the hospital, his wife Rebecca visited him with his lawyer, Mr. Van Vicker, who also was a senior counsel, and asked him to make a will. He mumbled a few words in annoyance, and Mr. Vicker SC wrote the following ones. I bequeath all my other possession to Rebecca, my first wife, who shall have discretion to share out my estate with another dependent. I appoint Rebecca and Van to be executor of my will, dated September 2020. Van Vicker and Rebecca signed the document and asked Mr. Wessler to sign, but he could not in his lucid moment and was unable to sign. So that's a possible question here, is whether this is a valid written will. Maggie gave birth 2 months later, and she visited Mr. Wesley with a newborn baby, a child born out of wedlock. What rights does she have? He was so excited, and the doctors were happy that his excitement triggered his memory, and he even named the newborn baby Wesley Jr. Maggie visited every other day. 3 days before his scheduled surgery, one bright Saturday afternoon, Mr. Wesley asked his Dr. Benjamin and his best friend and confidant, Aston Jones. He also asked for the nurse on duty, and he was told Dr. Benjamin to write down the following. Maggie, given so much joy in my old age. In case I die, I've given Maggie house number 154 Board Street as a gift. I shall immediately instruct my London lawyers to effect the transfer immediately. I am proud of my last born son, Wesley Jr., who is just an infant. All the other children are adult. To avoid missing out on my estate, I give and bequeath my 10-acre ranch to swim in the sweet waters to Wesley Jr., which shall be held trust for him by his confidant, Aston Jones. The rest of my other assets and possessions shall devolve to my 3 wives in equal shares, who shall have a ripe interest, and the same after which shall devolve to the children. I appoint Aston Jones and Jamie as joint executors of a will. So that this is another will done. Does it? There is a possible gift here, or gift in contemplation of death, or this is a will that revoked an earlier will. Those are possible questions. Mr. Wesley appended the signature. Aston John, Dr. James, Maggie, and the nurse duty or sign the document as witnesses. Maggie is a beneficiary, and the other case there, Rebecca was a beneficiary. Both of them signed the will. what is the issue of the validity of a will for beneficiaries, for people who sign as witnesses and they are also benefiting? That is a possible question. You are right that. Mr. Wesley then made a call to his London lawyers and instructed them to effect the transfer of the board seat house to Maggie. He further told them Maggie would contact them directly to give her details. A week later, Maggie received the transfer deed from London and visited Wesley in hospital so as to get him to sign it. He was not able to sign on her first two visits, as he was not in proper state of mind after surgery, but eventually signed on her third visit and told her board seat property would belong to her if he died. Maggie executed her part and later sent the transfer deed and all the documents to London lawyers. Mr. Wesley died 2 weeks later after suffering. So now this property here, all the things that were done, all the things were done in contemplation. Then this man died. Mr. Wesley died 2 weeks later after suffering a blood clot in lungs. After burial, Aston Jones called a family gathering and read out the context of the will dated 10 December 2022. So the will here that was read is the later will, not the first one. Rebecca was not pleased as she believed being the first wife, she was entitled to the larger share. She thus informed the gathering that the deceased already had made an oral will dated 13th September 2020. So we are told now that in this question that the 13th September 2020 was a will. That's now a good information, which came before the December will. So question one usually is a question that has a lot of things. It tries the candidates with on so many issues. So we can read the question. In light of the narrative, with the help of case law and ever statutory provision, discuss the validity of otherwise of the will dated 13 September 2020 in relation to the will dated December 10, 2022. So it tells you to compare and contrast the two wills. So what do you think, Marianne?
So for a will to be valid, and all of them were written wills, yes?
Yes.
Yes, because he signed it. So for a will to be valid, there has to be, the testator must have the mental capacity to write the will. Yes. The will must conform to the formal requirements, and the testator must have the knowledge and approval of the contents of the will.
Yes.
So those are the three things that should be in both wills. And yes. I guess I would discuss them, that the testator has to have both the age, the capacity in terms of age, and the mental capacity. And the mental capacity is in three forms. He has to be able to understand the effect of the writing of the will. He has to remember the property, and he also has to remember the dependents he has to provide for and the effect of not providing for them. Then the case you can cite in that one, of course, is Banks versus Goodfellow. Mm-hmm. And in the event that maybe he has an illness of the mind, there has to be, it has to be to the extent that the illness of the mind affects his ability to dispose of the property in the will. Mm-hmm. Then with regards to the formal requirements of the will has to be written. Mm-hmm. These are the will has to be written. The will also has to be witnessed as per section 11. Mm-hmm. And the witness need not do it. Okay, it has to be written. Then the testator has to sign, and the witnesses have to see him sign the will. Then the attesting witnesses should also attest to the will itself, but they need to do it in the presence of the testator. And then, of course, Section 13 talks about where the beneficiaries witness the will, and it says that if the witness, the beneficiaries witness the will, then there has to be two additional more witnesses that attest to the will, two independent and competent witnesses. Then the other one, of course, is knowledge and approval of the will. So there can't be fraud, importunity. There should not be coercion or undue influence. Persuasion is allowed, but the rest are not. So in this case, of course, the issue of the validity of the written will, in the first will that was on September 13th, I think, the will was written and it was signed by the testator. However, the first issue is, did the testator have the mental capacity? It was shortly after his accident and the coma, so I am not sure the testator had the mental capacity to do this will. There is also the element of the undue influence or importunity on the side of Rebecca, the wife, coming when the husband is vulnerable to make this will and taking the major share of the properties in the will. So there's also the suspicious circumstances. There's also the fact that the witnesses who attested to the will were Rebecca and the senior counsel. So Rebecca being the main beneficiary and also the one who attested the will without additional competent witnesses attesting, two additional witnesses attesting to it will make the will fail. So the will of September 13th is actually invalid on those grounds.
Okay.
Then we go to the will.
Before you go to the next, we also told he was unable to sign, eh?
Oh, okay.
Yeah. So it was unable to sign. So also that's another ground. And also discuss now, because now the question says, of course, all what you have said is correct, that Rebecca says that the oral will dated 13 September was an oral will. So discuss whether it's an oral will. I want to hear that.
Okay. The requirements for oral will are that it has to be done in the presence of at least two competent witnesses, and that the testator should die within 3 months. However, I think he died much later. The will was on 13 September. When did he die?
He died.
I had just seen it.
Let me tell you.
He died much later than that.
Yes.
So the will also fails as an oral will.
Okay.
Yes.
Now go to the next will now. The one dated the day of December 2022.
So that will, it is a written will as well.
Yes.
The testator, so it's written, so it qualifies in that sense. And then there's also the fact that it was witnessed by Dr. Benjamin and Ashton Jones, who were also appointed executors. And as per Section 14 of the Law of Succession Act, executors are not barred from being witnesses to the signing of the will itself. And then attestation was also done in the presence of the testator. So it fulfills the formal requirements of the will. At this point, with regard to the capacity of the testator to make this will, the testator had recovered his memory shortly after the visit by Wesley Jr. He'd recovered his memories and could articulate himself. So clearly he had regained his mental capacity to do a will. And of course, it was with the knowledge he knew the knowledge and the contents of the will because he was directing actual distribution, naming actual. He remembered all the dependents. He remembered his property, and there was no undue influence or pressure because these were independent persons who were guiding him to make the will. So I believe the written will on 13th December is a valid will.
Okay, the 10th December 2020.
Oh, 10th December, sorry, 2020.
Sawa. That is the analysis. That question you have answered it very well. This is an analysis that students usually don't are able to do when you are told to. Otherwise, you because the question is very clear, you must compare and contrast. As we are aware, you have done, and that's why this question had a lot of marks. The possible drafting to this question, other things that we can add are that you can be able to be told to now to draft to take the will to the court. So how do you do? That is a possible question, Maria. How do you go about it?
Come again. I did not get that. Please come again. How do I?
How now you are told that assuming that the 10th December 2022 will is valid. Now you are told now to take the will to the court, or to make sure that the estate is distributed. What would you do?
So this is a valid written will, and it has also been named the executors of the will. So I would do a petition supported by an affidavit, and I would annex a copy of the will along with affidavits for the what is it called? For the justification of the executors in this case, and then justification for the proposed sureties, and then the guarantee for the sureties. Yes, that is how I would go about it.
Yes, petition and affidavit on justification and sureties and the original and because the executors are there and the will, you apply for granted of probate. That is the process you need to know very well. And that process is in page 12 of the Angawa book, the small book. These are questions that have been asked many times, and it can be repeated again. Also, I want us, if you look at question 1, June 2021, also asked something similar to this question. And there are case law there. I think we can also look at the answer given by the best performing student. That is question 1. He got 13 marks. Question one. Question 1 is projecting on the screen. Variety expected, discuss the variety of other ways of the will. Section 5, provided freedom and mental capacity. You have discussed that. From the facts event that Wesley hence with regard to mental capacity, there was sound consideration. Lack of mental capacity does not necessarily validate the will. This is because a will is made before such a capacity till the moment of lucidity is still valid, as discussed in Vidya Chandrata versus public trustee. So these are very, very important cases, the Marianne, you need to have it. This mental a will made during a moment of lucidity is still valid. That is the case. The test for mental capacity was in Banks versus Godfellow that we have discussed. Knowledge and approval and the influence you have discussed. The formality, written will, then he discusses the will that in December 20 will, and the influence, the requirements, section 9, section 13, and he makes the Nini invalid, as we have discussed, and then the other one was valid. So this is, you just need some case law there. So we can go to the next question. Aston Johnson has decided to petition for grant. He has approached you. Name 2 main pleadings to be filed in court. In fact, we already, that one we have already said. I did not, what are the 2 main pleadings what are the pleadings there, Marianne?
The petition in Form 78, and then with a supporting affidavit.
You can be able to draw them?
Yes, I think I actually did it for this question. I did it.
Oh, you did it, eh?
Yes, yes.
You sent me?
Yes, I did for this year. I may not be able to do for the other year because I'm doing other subjects at the same time, but I did for this 2022 year. I did, and you said to do any possible draftings that came about. So I did this one, this petition and the supporting affidavit. I did objection. I did citation. I did the limited grants. Yes.
I had not gotten that. I thought the drafting you sent was for October for March 2023. So that's very, very important because drafting, we are here because of drafting. Let me download now, and we can look at that. That's very, very important. Shows that you are someone who is very diligent.
I feel like the drafting for probate is not that bad because it's the standard forms for everything. So I'm not really struggling with the drafting for those. It's I don't know if it's the understanding of the question I'm struggling with, what to apply in a specific question.
Okay.
Yeah. So even if you don't look at a lot of drafting for probate, it's fine because it's a standard form. So I just need, as long as you remember which one, because it's mostly petitions and summons. As long as you remember what is for petition, what is for summon, and then for the specific one like citation, I think drafting ya probate si mbaya vile. Ile nitakutumia uangalie ni estate accounts.
Okay. Estate account now, that one now. estate account, you know, that is that one needs someone. That's one, you know, that is beyond even probate ni maneno hata yeah, someone who has done accounts and has some knowledge on that. It's not purely probate.
Yes.
So that one I need. I'll be lying if I say I can be able to do the. In fact, that if you look at the year 2008-29, I did not do those estate account. I need someone who has that knowledge to do.
Okay, I'll look at the question and then I'll give you feedback on that one.
So
I'll look at it probably the weekend before.
So we can let us shelve the drafting, Cindy.
Yeah, we can shelve drafting. Let's just look at application of theory in questions.
Okay, sawa. So the third wife, Marianne, decided to discard both wills and sought legal help. She has insisted that the deed are instated and his property should be divided equally among his three households. In her case, that Maggie should not own the board street and her property as she is not known in the family and she was a gold digger, not worth of any asset from the disease, and that the board street property should revert back to the deceased estate. Maggie has approached you for legal advice. With the help of case law and statutory provision, evaluate Maggie's claims as regard to board street London property. So what do you think?
So this is gifts in contemplation of death. Donatio Mortis Causa. It's in the law of succession. It's covered under section 31, and then the guiding cases, principal cases are Kane versus Moon and Rivermont. So in this case, I would discuss the principles of Donatio Mortis Causa, which is it has to be a gift in contemplation of death. In this case, our testator was in hospital and it did look like he was going to die after his head injury. Then it has to be conditional upon the death of the donor. So the transfer in this case was supposed to take place after. No, it was supposed the transfer. When was the transfer supposed to take place in this situation? I'm not very clear on that. He told Mr. Wesley said something that this house would be yours no matter what. Something. He was not able to sign then made a call to his London lawyers and instructed them to effect the transfer of Bond Street house to Maggie. So in this case, it was not conditional upon death because he effected the transfer in life. Then there was the issue of the whether it was delivered to the beneficiary. Mr. Wesley failed twice to sign the transfer deed, but he eventually signed it on the third visit. So, and then whether it is capable of transfer, so it has to be free property. This was property belonging to Mr. Wesley, so it was capable of being transferred. The lady Maggie survived Mr. Wesley, so she survived the donor, and then it's only recoverable in the lifetime of the donor. When I looked at it, it was very obvious they were asking for Donatio Mortis Causa, but then I was wondering if it can also be a gift inter vivos, because it was given in life and I did not see the condition of death.
What is the difference between if it is a question between what is a gift in a lifetime gift and a gift in contemplation of death? How do you differentiate them?
For gift in contemplation of death, it has to be conditional on the death. In gift inter vivos, it's just that it's given in the lifetime of the donor, and then the donor must intend to give the gift, and then he must effect the transfer. In this case, he effected the transfer, and then the subject matter is delivered to the donee. In this case, the transfer deed was given to Maggie. So the donor divests himself of the property, and then it's unconditional to the donee. So in this case, there was no condition or upon death or anything. So I feel like it should have been gift interviews. Although I can understand why, even I initially thought it was donation motus causa, but then I'm not seeing the conditional part for death.
Yes. That is correct. There was no because this man did not know he will die. But you know, in the gift and contemplation of death, they usually say that when I die, when I'm giving you this because I want to die. But here he did this transfer. He appended signature, signed the document, came to London, lawyers contact him. Then Maggie received the transfer deeds from London and visited Wesley in Oslo to get him to sign. He was able to sign on first two visits, but was not proper in statement, but eventually signed on the third visit and told her that the board seat property would belong to her if he died. Signed her a visit and told her, signed on her visit and told her the board seat property would belong to her if she died. Maggie executed her part and later sent the transfer deed of the cost to the London lawyer, Mr. Wesley. So this is a condition, Nani, Marianne, you can see. The property would belong to her if he died. So
okay, then it's donation.
It's donation. That is a condition there, because in this state he knew he would died. Then we are told that he died 2 weeks later. So he knew he would die. So this is a donatio moksha. I usually don't gift in contemplation of death. I usually have a difficulty pronouncing that term. Possible question is what we have discussed. You must know you can also be asked about a gift given during lifetime. It was asked in the past. I know I have done research somewhere. I remember doing research. I don't remember the exact question. It is there. It has been asked. Donatia, it has been asked very many times. Yeah, here there is nothing you can be told to draft really. And the question given by the student, we can check the best performing. I don't think there is much we can add. Board Street, he discussed section 31, the principles gained by Zosmoon, which are directed in the question. You need to understand those principles well. In gifts in contemplation of death, which are about in section 31, which are about 6 principles. And then you can be able to answer this question. Yes. So we can go to the there is let me see. There's something I think there we can add a little bit. I'm going to page 182 of year 2008 to 2008 to 2019 past papers, page 182. I think there is a case law there, which I need, I found to be very, very important to this question. We can add on it. Okay, you can look at page 182, 185. I have discussed the conditions in details with some case law. There is also because the Law of Succession Act here says that gives movable properties. And this year, this person, Maggie, got land. Or do you think can immovable property be transferred in a gift in contemplation of death, Marianne?
We've had this discussion, not in class, but with my friends, and we are not sure. Because the Act just talks about free property. And there's some case law where we talk about giving of land, even in donatio. So, and the courts have approved. So it's been a question, because I know there's case law. I don't know where I have it, but there's a place I had written where you're not supposed to give, like, of course, they can't be the ones that happen after, like, checks, but there's also a case law where it prohibits land. I'd have to look at my notes, but I know I have a case law that says you're not supposed to give land as donatio. Even me, I'm not sure now.
But for I have a case law here called in re-estate of Kabue or Lepate, this is 2018.
Yes.
It
Yes.
discusses inside there a case called Nalsi LJ in Sen versus Habri 1991. Chancellor 425. It says that movable property can be transferred. I think it is a very, very important case. You need to, because it can come as a question. Instead of Kabue or Lepat, you can look that on your side, Lepate.
Okay.
Instead of Kabui or Lepate, 2018, it discusses that. It says that they quote a case law there, an English case law there, and says that movable properties can be transferred. Because this question was given in contemplation of death, and it was a movable properties, and the answer was that I think that is what you are supposed to discuss. If also you have another case law on movable property cannot be transferred, I don't know. So you need to have knowledge on those case law in a question, because it can come again. Now for you to argue that way. Eh?
So I've checked my notes.
Mm-hmm.
Beaumont is the one that says you can't give checks and promissory notes. As Donato Motiscosa, but also there's a case for Dudfield versus Elwes that says land, either freehold or leasehold, cannot form subject matter of Donato Motiscosa. So now I'm not sure.
It was a case of which year?
I think this is those old English precedent cases, Dudfield versus Elwes.
Okay. Yeah, I want to, it has opened, I want to share, because these are questions that you can be asked in an exam. The screen is loading. You can write this case here, section 17 of 2016. Your screen is sharing the area estate of Kabue or Erepati. This is 2018. So this case was objections, revocation, revoked. So that was the object wanted to revoke, the we revoked. So in this case, they discuss so many things. In fact, they come to gift in contemplation of death, and they discuss so many things. So here, because when I was researching, I wanted to be sure whether land can be transferred in contemplation of death. So there is somewhere here. There is somewhere here. So a condition doctrine in a state of chancery where the court of the accusation which is issued for danger. So the conditions are all here, chancery. Then the other test is clearly illustrated in Nausi LJ in a Senator versus Hybrid 1991 Chancellor 425 held that the right on gift of contemplation of death to also apply to land interest. The learned judge stated the law and the requirements of valid class in the following language. First, the gift in contemplation of death does not necessarily in expectation of impending death. Secondly, not necessarily in expectation of impending death. Secondly, the gift must be made in condition. It must be absolute and perfected only to the donor's death, being revoked until the event occurs, and ineffective it does not. That day, there must be delivered a subject matter of the gift on necessary indicia of the title thereto, which amount to a parting with dominion, not merely physical possession. And that was shown there by the transfer. So, yeah, this case, I think you can, it is a case that you can quote, gift in contemplation of death. You also include land interest. You can also, the case that you are saying you can find it, also argue on gift in contemplation of death does not include land. And then, because this can come as a question, a standalone, then you can make your own finding or conclusion. So I thought that was very, very important. So we can continue. The next question. And I want now to share the screen, the question of the screen. The question paper, we continue. So the next question is here. B. Assume that both these were nullified and the court has directed for the matter to proceed as if the deceased died intestate and appointed all the three wives of administrators. They are all refused to consider Wesley Jr. saying he's not an illegitimate. Wesley Jr. saying he's an illegitimate child as his mother was not wife of the deceased. Briefly discuss whether Wesley Jr. is entitled to the share of the estate of the deceased. So these are very common questions where there are children born out of wedlock. I can assure you it will come again in these exams. It usually asks like every time. There must be questions somewhere asking you on children born out of wedlock and petitioning of letters of administration of will intestate. Petition for letters of administration intestate, or where intestate the rules applied. These are two questions that you cannot miss in every probate question. So what do you think, Marianne?
So Wesley Jr. is a biological child of Mr. Wesley. As such, he fits the description of a child in Section 2 of the Law of Succession Act that incorporates children born out of wedlock by the mother. And then for the father, what is it? I think it's also children born out of wedlock.
Yes.
Yeah. So Wesley deserves a trust, and he is also qualified as a dependent under Section 29A as a biological child of Wesley. So he doesn't even need to show dependency. He's an automatic heir to Mr. Wesley, so he deserves his share, which can be held, of course, trust by his mother Maggie and another administrator as a continuing trust.
Okay. Now, that is good. When you ask a question on children born out of wedlock, the first starting point is the Constitution. You come at Article 53 on the children. Before even you go to the law of succession, Article 53, 1E, which says that every child has a right to parental care and protection, which includes equal responsibility of the mother and father to provide for the children, whether they are married to each other or not. So that is the starting point. You quote Article 53(1)(e). Then you go to Section 2. It's not Section 2, it's Section 3(2) of the Law of Succession Act, which defines children to include children who are born out of wedlock, even children who are conceived but not yet born, but are born, provided it can be proved that the child was conceived by the man before he died. Even a children he has expressly recognized as child of his own and voluntarily assume parental responsibility. This is another scenario. Of course, you have been told about Section 29(a). What is the famous case in this question? The famous case law in this question is which case law?
I don't recall.
Yes, the famous case law which is usually used, and you are going to remember very well. It is called Mobea versus Mobea. But the best performing candidate said Mabea. It's not Mabea, it's you. Mobea versus Mobea. Remember that. Children born out of wedlock are entitled to inherit from their father. It's a very famous case. It's a case that is like Bank versus Godfellow. So that is a case law you will use. If you are told to move to court to help this child, what will you do, presuming that the question is asking you that, which is the application and what are you going to do?
I think I would do an application for reasonable provision and under Section 26, 29, Article 53, and is it Section 43? Yes, of the Probate and Administration Rules, asking for reasonable provision to be given for Wesley Jr.
An application for reasonable is done through? How do you do it?
Okay, so sorry. So the rule provides for two situations. If it is before the grant has been applied for, the grant of probate has been applied for, then we do a petition and a supporting affidavit. If it's after, we do summons and a supporting affidavit.
Very good. There are students who usually says that because someone has not been provided as someone, if there is someone has not been provided for as a beneficiary, they revoke the will. That is very wrong. Some students say usually you don't, when you are dependent and you are looking for reasonable provision, you have not been provided for, you have not been recognized, you do an application for reasonable of course you can with those two scenarios that you have said, and you can be told to draft, and you need a case law, especially after the amended case law. That one I did not look, I did not find, but for the purposes of this question that is coming in the exams, look for a case law where a child moved to or a beneficiary was not provided for in a will, and then he moved so that he can be reasonably provided for. Just to have a case. Are we together?
Yeah, I have Ndolo versus Ndolo and Ruben Nzioka. Although in those ones, I feel like it was mostly like, especially the Nzioka one, it's a woman who wasn't considered a wife who was being provided for, but I look for a child who wants to be provided for.
Yes, there. I think you can find in Kenya Law, in the Kenya Law website. That one I did not research because, in fact, it had not occurred to me, and I don't think they have tested. From my research, I don't remember quoting any case law for children. I think I had a difficulty finding, but you can find a case law. It is very, very important for the upcoming exams. So we go to the next question. Peter and John were minus 13 and 14 years respectively. Every time,
before you continue, I have a question.
So,
if it's this child that has been taken as their own by the testator or by the deceased,
yes,
that there must be, okay, in my class, as we learned, Madam Anastasia did not really clear up. Initially, she'd said there should be an adoption order, and I had found a case law for that. I think it was in the estate of someone a minor. But then now, when what does this child need to prove to show in the event there is no adoption order? Because there's also the case of like Como versus Como, where they said like just payment of school fees is not enough. So I just stick to the fact there should be an adoption order, or is there anything else I can say in that situation?
Yes, I think it is an adoption order because proof of someone that you have taken a child. I think, in fact, it's a question I remember it was asked somewhere. Have you gone through the Q&A?
Not yet. I'm not. I'm planning to do LWD and probate Q&A the weekend before the exam.
Yes, I think it was asked somewhere. Our rights here have the rights have gone off, but my laptop has some charge. We are going to continue. It has 39%. I hope it is going to come. You must have been adopted. I think I did that from the Q&A, because you see, if for example your uncle takes you and you start to live in this house, and you are eating in the house, you are paying school fees, and does that mean taking you as his child? I don't think so. The proof of someone you have taken someone as a child is that the adoption should have gone through. So the correct position is that the adoption process should have gone through, and the person ought to have taken the adoption order given, and of course, after the adoption order is given, you take the parental responsibility. Sawa?
Yes, Mwalimu, thank you.
Yes, and I think it is a question that was asked somewhere. I remember doing research on that. You can ask, you can look at it, and it's very, very important. It can also come, by the way. So Peter and John were minors, age 13 and 14 years, respectively. Of course, when the student know that there is a continuing, the possible question that can ask you is the things to do with continuing trust. When their parents died in a traffic road accident, the Auntie Jennifer was appointed as a administrator of the estate of the deceased parents, and the court appointed the Uncle Thomas to hold the net estate in trust and their benefit until the age of a majority. So remember, when there's a continuing trust, there must be 2 administrators. Which section is that?
I know it's 60 something. I can't remember it often, but it's 60 something.
Yes, it is section, I think, 55. It is also a very, very important question that is usually, no, it's not 55. Confirmation of grant. Okay, we can continue. It is somewhere because of time. Unfortunately, after their parents' funeral, the 2 children were chased away from their parents' parochial home in order to go and live. Verify that section for exams. Unfortunately, after the parents' funeral, the 2 children were chased away from their parents' parochial home in order to go and live with their parents or grandparents in Bomet. Neither Jennifer nor Thomas paid their school fees or their other needs. The children dropped out of school and lived in abject poverty on what their aged parents could provide. Peter and John are now 20 and 21 years respectively and have run of various legal awareness programs held in Bomet, and that is possible to get back their parents, late parents. Thank God the electricity is back. That's why we usually pray before this is before the start of the class. The 2 children dropped out of the schools. Respectively, various legal awareness programs held in Bomet that was possible to get back their late parents' estate from their uncle and aunt. They approach you and as the advocate based in Bomet for advice on how they can assert their rights of their heirs and their late parents. Advise them on the duties of Jennifer and Thomas with respect to the estate of the deceased and whether they discharge their duties. A very common question. Duties of the administrators of the estate and whether they discharge. So what do you think?
So, okay, for correction, for that part for executors, you refer to section 56 and rule 25 of the LSA. Those are the ones that provide for the number of administrators. Specifically, rule 25(6) provides that it has to be joined to 2 or more persons, especially, but not exceeding 4. I can't find specifically for continuing trust.
Yes,
I will find it.
Yes, it is there. It is there. Very, very important.
But with regards to the duties of the administrators, so of course, it's provided for by Section 83 of the Law of Succession Act, and your first duty is usually to pay for a reasonable funeral for the deceased. Then you're supposed to collect the property and any debt owed to the deceased, and of course pay the debts owed to the deceased. Then you're supposed to, of course, have the inventory for the assets and liabilities within 6 months of confirmation of grants, especially in cases where there was no will articulating those assets and liabilities. Then you have to pay out of the estate. You should pay for the cost for administering the estate and distribute the residuary to the heirs and beneficiaries. Then you have to keep account because you may be called upon by either the court or the law might require you to give an account of the estate. Yes.
So
yes,
now you have said that. Now apply that to the question, and you say whether they discharge. Now I want to hear your application on the question.
So in this question, Jennifer and Thomas were supposed to establish a continuing, okay, they were supposed to first pay them for a reasonable funeral for the deceased, the parents who died in the accident. Then they were also supposed to be collecting the debts owed and paying the debts of the deceased. In this case, the two children have to drop out of school and live in abject poverty because based on what their grandparents could provide, so they were not paying the
school fees.
School fees, yes. And then they were supposed to distribute the residuary of the estate to the beneficiaries. The beneficiaries in this case are Peter and John, and they lived in abject poverty, so that was not done. Then, of course, the administrators did not give an account of the property to the court. And then those are the ones I can see.
Yeah, it is a question of 3 marks, so you have answered very well. You must the question after you know the law, you must apply on the fact that is given on the question, and then you must give your conclusion. Then section 84 is also very important. When the administrator of the estate of deceased person involves any continuing trust, whether by life interest or minor beneficiary, the personal representative shall, unless the trustee who have been appointed by you for the power of trust, be trustees thereof, provided they are valid polygamous. So they are trustees of thereof. So they are trustees also to the continuing trust. That is section 84. Which they failed because they did not do their work as continuing trustees in this question. So after discussing what you have discussed in section 83, you go to section 84. We can see if there's anything we can add from the best from the best performing student. In the present scenario, Jennifer is appointed administrator person of the deceased estate, while Thomas is the trustee. Continuing trust created under section 41 of the Act. What we are asking, continuing trust is under section 41. Let's see if it is correct. Because remember this student was doing in an exams. Yes, she was very right. In section 41 on continuing trust, you need to know that one. Notably, that continuing trust must continue until the children become full age. With regards to personal representative, section 79 provides that upon being appointed a person or the deceased, free property vests on such personal representative. Very important point. I like this with the way these students understand the law and quotes it. He had crammed very well. Property of deceased vests in the personal representative, a very important section. When the grant is given, all the property vests on them, but it's not for them to use, is for the beneficiaries. Duties, you have discussed that. We need not to go so much on that. So that is it. Very important section there. Section 41 on continuing tax, for 79 on property vesting on the personal representative, section 83 on the duties, and section 84 on the duties of the trustees, on the continuing trust to act as trustees. Are we together?
Yes, we are.
So we go to next question. this question you cannot, there is nothing to draft. You can hear me, Marianne?
Very well, Mwalimu.
Yeah, we had a technical issue. Various rental properties in Eldoret town, which you did Kenya shillings that, amend the rate, shares in various companies worth 5 million. Since she appointed the administrators, as Jennifer have been collecting the rent and dividends from shares and be spending it all on her family. Jennifer refused to dispute the property as the letters of administration, and in fact, stopped talking to any family member who raised a concern how he was handling the estate. Using the various statutory provision and case law, advised Peter and John on the appropriate steps to take to recover their inheritance. So, appropriate steps. So, what do you think?
So my advice to Peter and John would be they have to apply for the revocation of this grant. They will do this application under Section 76 and Rule 44 of the Probate and Administration Rules. And then they will, of course, talk about the fact that Auntie Jennifer has not been a good administrator and has not been administering the estate diligently and has failed in her duties. And then after they may also require her to take a full account of the estate and how she's dealt with it, and may even apply to recover proceeds that she has wasted. And then they themselves may now apply for grants.
Yes. Grant of letters of administration intestate.
Yes.
So, you need a case law there. Drafting, I know you have said the process, drafting letters of revocation. The most, because under Section 76, there are so many grounds, and different scenarios are usually presented in an exams. And you see them in the Q&A. But the most appropriate section here is Section 76, D2. Proceed diligently with the administration of the estate. And I tried to look for a case online where someone had not done. Of course, they are wasting the estate, using it on their own. I couldn't find. Do you have a case?
On revocation, no, unfortunately, I also don't have one.
Yes, I have on other areas, but on this specific area, I did not get. So after I upload this video online, if you view as and you have a case law, you can type there on comments. A case law where a grant was revoked for not for the administrator not proceeding diligently with the administration of the estate. That is Section 76 D2. Of course, this means they have been wasting. The other, you can be asked, of course, before we on that, let's first of all look at the answer that the best performing student gave. John, revocation of grant section and rule, probate administration, the grants for that that the administrators has failed to diligently administer the estate and failed to provide an inventory. The procedure is that they should file an application for revocation by way of summons, accompanied by an affidavit stating the grounds seeking for revocation. The matter will then proceed for direction ex parte, where the application will be given direction to Jennifer Thomas. Upon proper service, the court will issue a notice to Jennifer and Thomas for hearing to determine the matter. Peter and John should also make an application to court for the Thomas and Jennifer to produce full and accurate account. So that is the process of revocation. Under that ground, the other grounds that I have discussed that are there, you can be asked. For example, defective in substance, where, for example, the administrators omitted a process in the process. Maybe they did the process in maybe they did not attach the guarantors affidavit in the application. They did not name more beneficiaries. That is 76A. Fraudulent for concealment of or making false statement. For example, this is the question also asked a lot, many times. It is there in the Q&A. Where, for example, the one wife does not say that there is another wife somewhere or children. That is obtaining fraudulent and true allegation of facts and essential point of law. Then E, the grant has become useless and palliative through subsequent circumstances. This is usually where the administrator is appointed, then he dies during the administration. It can be revoked. Oral Q&A, you can look at it. It has some case law on that. I discuss each and every case law you need, even in the Q&A. Question 4, July 2016, tested on drafting an application for revocation. We will not have time to do drafting. Are we together, Marianne?
Yes, Mwalimu.
So have each and every scenarios under each subsection of 76A, and have a case law there. And I have given you where you can get oral Q&A. I did some case law there. Even the past Q&A have some case law. You need a case law under each ground and understand each and every scenario. So we go to the next question. The next question is, the siblings feel agree that the education was compromised and the standard of living was as a result of action of the Jennifer and Thomas. They are wondering if they are any members they can accrue personally to their auntie and uncle. Advise them. 3 marks. The other question was 4 marks. So what do you think?
Sorry, the remedies that Aunt Jennifer can apply to herself were, that's, I don't know. Okay, the one that I know of specifically is usually the statute of limitation, but in this case, has it lapsed? Like for
negligence.
what is that one called? The one for wastage, devastate, that she was an accomplice. But in this case, she didn't even pay for their school fees. So she's not even an accomplice in the wastage.
Yes.
That she acted honestly and reasonably, maybe the reasonable part, not very much honestly, under Section 16, I think, of the Trustee Act. I think those are the defenses I know. I don't know. I don't know which one would apply in this situation, but those are the ones I know.
So these are the siblings. They are aggrieved. These are also a very common question. Was compromised the standard of living. So where they have recourse against Jennifer and Thomas for wasting their life. The relevant section is section 94 and 95. You see, every time a question on duties of personal representative where they have wasted, you are usually ask their duties, and of course they will usually have wasted the estate. And then what are the remedies? So now you come to section 94 and 95. That is 94, where personal representative neglects to get an NSZ forming part of the asset in respect which the representative have been granted to him, or misappraise or such an asset or subject to loss, he shall be, whether or not guilty of an offense on account, be able to make good of any loss or damage so occasion. So they can be made by the court to be liable to make good any loss or damage, then to pay back. Then section 95, criminal charges, they can be charged for willful and reckless neglect, and they can be guilty of an offense liable for a fine not exceeding 10,000 or imprisonment of not exceeding 1 year, or both fine and imprisonment. Of course, the Law of Succession Act was enacted long time ago. These kind of fines need to be enhanced, and they are usually very low, even for intermeddling is very low. I think it's also 10,000. Needs to be enhanced. So those are the two remedies. 94, making good loss, that is civil, then criminal. You report to the police, and they can be arrested, charged in court for criminal offense. So that is, of course, on this one, I don't have a case. I tried to find a case. I did not get. So you can try to look at, do you have a case on this? Marianne?
Yeah, sorry. My mother was talking to me. Sorry, come again.
I'm asking you if you have a case of section 94 and 95.
For defenses?
No. For liable to make any good loss, where administrators were found to be liable.
Let me see. No, not okay. Let's see the full trial. Okay, I cannot see directly. The ones I have, I don't even know what they're on specifically. I have for devastate. No, I don't have for making good. I don't have.
So I also did not find. We need to, and there's a lot of banging on your side, eh?
Sorry?
There's banging sounds, eh?
Okay, sorry.
Yes, please concentrate. Let's finish this business, eh? So find a case in section that can help you under section 94 and 95 of the Law of Succession Act. Sawa?
Yes, Mwalimu. If I find one, I will forward it.
Yes, I did not also find. So we are halfway in the Q&A. We are now at question. No, we are not halfway, but the time is already almost, it has gone halfway. So we need to hurry up. Now we are in question 3. Section, it's good to look at what the best performing student did. Section 95, criminal actions. Yeah, discuss section 95. Diligently undertake their mandate. So also you add section 94. So I go to the next question. That is question 3. Mr. Mzuri, Mr. Zuri passed away 5 years ago, leaving behind 100 acres of land in Wakada County. At time of his death, he was a widower. He was blessed with 5 children and one boy and 4 girls. The boy, Diamond, was the apple of his father's eye, being the only son of his firstborn child of the family. Diamond, upon death of his father, Mr. Zuri successfully petitioned and was granted letters of administration of the estate of their father. He then transferred the said property and had it registered in his name. The process was undertaken secretly without involvement of the siblings. So, up to that point, the siblings were not involved, the girls, the 4 girls. So, even before you look at the question, what is asking you, you know this grant will be revoked on ground, which ground? 76A, which we discussed that the one I was telling, the proceedings to obtain the grant were defective in substance. The grant was obtained fraudulently by making false statement or by concealment from court of something material to the case. That is 7B. So because it was obtained secretly. So do you see how you identify the issues, Marianne?
Yes, Mwalimu, I can see.
Yeah, so, but blessings of the process was that secretary without involvement of his siblings, but with the blessings of the elders and the clan. The siblings' law in the meetings between Diamond and the elders was limited to ensuring that the elders were well fed and comfortable. At one point, the siblings were summoned to a meeting and told that the said property would pass to Diamond since they were remarried with their husband, and they should be given their land, given them land, and Diamond should be left as he wished with the property. So this issue of ladies or girls, because they are disinherited, because they were married off, is also a very common question, comes a lot. You need someone needs to be keen on that. Diamond has now passed away in a boating accident in Wakada County. So the son has now passed. His wife, Miss Diamond, has commenced succession proceedings in respect of the husband, which relates to the 100 acres of land in Wakada County. The siblings of Diamond approach you to an advocate to advise you on the matter. So, discussing having regard to reverse statute and case whether siblings Diamond are entitled to inherit in the estate of their late father Zuri. What do you have to say?
So some of the facts of this case are very relevant to the estate of Mary Wanjiru Dairu. I think, I think that's the name. Well, it was 1 son and 6 daughters, and the son attempted to inherit the entire estate by himself. So that was just on a side note, but like in this one, like you said, the siblings have grounds to revoke the initial grant and stop the transfer. And the initial ground the initial grants granted by their brother, because of course he concealed material facts that he was not the only beneficiary and that
I want, we are going to come to that. I want to remit. Of course, what you have said on the case law is very, very important. It has gone on the record because after the exam, I'm going to research this question afresh, and I'm going to upload them on the website. So that case law, I'm going to listen to it, and I'm going to use it. So that's why we add so many things in these questions. But the question is asking, discussing having relevant statute and case law, whether the siblings of the diamond are entitled to inherit in the estate of the late father. So relevant statute and case law.
Okay, I think I would talk about then Article 27 on discrimination and gender. I would also talk about Article 10 of the Constitution that talk about equality and the fact that there should not be any discrimination again based on gender. Then I would talk about the fact that case for Mary Wanjiru Thairu, that distribution is equal. Also another one for Kenyoru Karanja, where it said there should be equal division of property, that they do not favor one over the other. I think those are the ones I would talk about. Okay, that's good. Another very relevant section, of course, the main statute. You start with the Constitution, Article 27, for on no one shall be discriminated on any grounds, including gender. Then come to Section 35(5) of the Laws of Succession Act, which says that Section 39, then Section 41. All these sections are relevant, and that ladies cannot be discriminated. There's also a famous case in Rono versus Rono. It's a case usually used very much. Is where the man tried to disinherit the daughters, but the law say the code says that the daughters cannot be disinherited. So that is it. We can go to the next question. I don't think that's we need to belabor much on that question because of time. Mary Rono versus Jane Rono. This is a 2005 case where the girls were nini. Yes, we are to be disinherited because they were married off. So I think you can go to the next question. Advise the siblings on the specific steps and legal process to be taken to pursue their rights to their father's estate, if any. So what is the answer there? They should pursue revocation of grant. Okay, my issue with this one was if we just revoke grants, can we ask court for something else, like an injunction or something, because of the transfer that happened? Or if we revoke grant, will that also revoke the actions of the administrator and revoke the transfer of the land?
Yes, it is revoke. Yes, it revokes revocation means everything. They usually revoke everything done. So,
okay. Yes, thank you.
Yeah, so the specific steps. So, how do you go about revocation of grant? Because it's asking specific steps.
So for the revocation process, I would do an application for revocation supported by an affidavit. The revocation application, of course, is done in the prescribed form under Section 76 and Rule 44 of the Probate and Administration Rules. Mm-hmm. And then the application, of course, is done in the High Court of Kenya, which has the original jurisdiction to handle this matter. And then the registrar, okay, do we do the whole procedure or just that? Just the application bit?
Yeah, it is talking about the specific steps. So you discuss the process, eh?
Okay. After the application is done, the registrar will issue a notice to the applicant to attend the judge ex parte. Yes, that's what I know. Yes.
And okay, another question. Let's for argument's sake, let's just think that this question, the value of these acres of land was not more than 20, or any property was not more than 20 million. Where would you go to for the revocation of grant?
So if it was below, I would go to I think it would depend on the pecuniary value, but I know the High Court deals with matters above 20 million shillings, and the magistrate courts deal with matters below 20 million shillings. So it depends.
Can a magistrate court revoke a grant which it has already been issued, or you appeal to the High Court?
I think I would still appeal to the High Court.
No, the procedure now,
yes,
is now you go to the same court. Eh?
Oh, okay, thank you. Yes.
Yeah, if it is is not more than the pecuniary jurisdiction, you go to for revocation to the same court. Eh? Revocation done after the law changed. The revocation is still done by the magistrate court, the court that issued. So any appeals, you go to now to the High Court. Eh?
Thank you, Mwalimu.
And that is very, very important. So we can look at the answer that the student gave. The student in this question, the highest performing, that is question 3. And of course, Kenya Road Kenya Road report, they don't report magistrate courts decision. So it is very hard for you to find a magistrate court's decision unless it is cited in the High Court. It's also good to have a case law. He did not do this question. He did 1, 2, 4, 5, and 6. He did not do the question 3. So we continue. What are the grounds, 4 grounds upon B above would you be premised? The grounds which B above would be premised, the grounds.
So the grounds is that the procedure for getting grant was defective, that there was material concealment of, there's concealment of material facts by the applicant, that is it that beneficiaries
Repeat
Sorry?
the start again. First ground.
Sorry, give me just a knock on the door.
So.
I was telling you about that is I was saying the first one, of course, is that the application for the grant in itself was defective.
Yes.
The procedure for applying for the grant was defective.
On how?
And then that
How?
it was defective in that the applicant, Diamond, did it in secret, not inform other members of the family when he was taking out the grant. That there was concealment by the applicant in that he did not inform the court of the other siblings and their needs for of course that they how do you phrase that? He hid from the court that there were other beneficiaries to the property. And then which other one can we use? Can we use the one for discrimination?
No.
Here?
Yeah, it is. That's why I was telling you to understand section 76.
Yes.
So 76A, the procedures to obtain the grant were defective in substance. So that is the procedure that is used was defective in substance in that you are supposed to name all the beneficiary. Okay, you are supposed to, what is it called? I think you need to
you should notify all the beneficiaries, especially in the priority, so that if you're a lesser beneficiary,
that one is what I was looking for. That is what you use in a. Then concealment of from the court, that is where you say that he did not name the ladies. Then the grant was obtained by means of untrue allegation of facts. Of course, saying that there was no other siblings. You use C, obtained by means of untrue allegation of fact, essentially a point of law to justify it. Then those are 3 points. That the person who the grant was made has failed and after due notice without reasonable cause, useless and imperative. So you discuss section 76A, B, and C, and you have some case law, and then I think you get your 4 marks. Get case law for each section, subsection, eh?
Yes, Mwalimu.
In the, I have, they are there in the oral Q&A. I discussed them. Each and every, even they are there. So you need a case law under each section. Because the exams can come for each and every section. So you go to the next question. Ali died intestate, leaving behind 2 sons, 1 daughter and grandson. Omari. Upon his death, one of the grandson, Omari, petitioned for letters of administration of the estate of his grandfather Ali. So why did he petition? And there were 2 sons and 1 daughter. That's why you ask the priority of the person who is going to petition. You just start asking yourself that when you are reading the question. Upon finding the said petition, Omar started bragging to his friend that is now a millionaire owner of the prime land and even put it for sale after gazettement of the petition. Can you be able to sell land when the grant is still there? Capital property. His auntie Saumu, who is the deceased daughter, learned of the petition by Omari and informed you to her 2 brothers, Rajat and Safari. Saumu. Two brothers, Rajab and Saumu, Rajab and Safari have sought your legal advice on the way forward. Identify two applications required to outline the procedure to be followed thereof in securing your client's interest. So, the two brothers, they are called Rajab and Safari. Safari Saumu. Rajab and Safari has come to you. Of course, this person have Omari applied for letters of administration, so the question is that identify the application. It is asking you identify the application required and outline the procedure to be followed thereof in securing your client interest. So what do you think?
So the Ali died intestate, so we are applying for grant for letters for administration in intestacy.
Mm-hmm.
And the application will be done. It's a petition in the prescribed form supported by an affidavit under Section 67 of the Law of Succession Act. And I think I don't remember the rule that applies. And then after your application, the application has been done by the grandson. So it will be an application for custody. So Saumu and her siblings can should object to the application for grants during the 30 days of engagement. If object, and they can file a caveat with the registrar to be informed of anything that happens in things. And then after they file the objection, the registrar will give them notice for which they can file either an answer to the petition or to the petition by the grandson. I may forget his name.
Omari.
Yes, and then the court can Omari, and then the court now can set the matter for hearing for both parties to resolve the issue.
So the grounds in support of the application, that is one mark. What are the grounds of
support is that Omari did not obtain consent for like Omari is not. Section 66 gives the hierarchy for priority of application for grants, and Omari is a lesser entitled person, and he did not obtain consent from persons with a higher
priority in ranking. So that is a question on objection. So this question of objection, protest, and revocation of grant usually confuses students very much. How would you know that the question you are supposed to file an objection here? You are supposed to file a protest. You are supposed to file a revocation of grant. How would you know in an exam this is objection, this is protest, this is a revocation of grant? How would you know?
So of course, objection comes in between after a party applies for grant. There's gazettement for 30 days, which invites any objection. So that's the period within which objection is done. Yes, revocation, of course. Yes.
And of course, the question here talks about gazettement of the petition. So that is the clue, the link. That is the clue that this question gives you, telling you that it is asking about objection. Revocation?
Revocation is always after the grant has already been confirmed.
Confirmed and the distribution is going on.
Yes.
Then protest?
I am not sure about protest. I don't know. I know protest comes after the period for revocation. I mean, for objection, but I don't know how.
Very good. That is a question that it usually confuses students. Protest, when you are told a question about that, you see a person there, a beneficiary saying that is protesting how the property is going to be distributed. Either this person was given higher shares, lower shares, nini. That is protest. It just come before the grant can be confirmed, so that the estate can be distributed. Are we together?
Yes, very together.
Yeah, so that a question on protest and has been asked. Look at the Q&A, it is there. And of course, objection have been asked many times, and then revocation. So student usually confuses the three. You will see someone saying that, for example, here that the grants need to be revoked. Of course, another a very, very important thing where it is can capital properties like grant be distributed before the grant is confirmed? I'm asking you, Marianne.
Yes, sorry?
I'm asking you, can capital properties be distributed until the grant be confirmed?
I don't think distribution should happen until grant is confirmed anyway. I would say no.
Yes, for no distribution of capital. That is things like land. That is section 55. So when you are given a scenario that someone started to subdivide land or selling and the grant has not been confirmed, you invoke section 55, which was also relevant in this question. And it has been asked so many times. Very, very important. So we go to the next question. Question 5B. No, 4B. Mr. Kani is a wealthy man who lived in London for his holidays. Mr. Khan visited Kenya for 2 weeks in February and August every year. To make his stay easy, he bought a land and built a home in Naivasha and Malindi in Kenya. He had Stanley to take care of his home by keeping them clean and gardening. Stanley also served as his cook and guide when he came for his holidays. He also hired stability property consultants to rent out homes to tourists when he was not in Kenya. Mr. Canning died in September 2021. Is there a limitation as to when you can apply for a grant of representation, Marianne?
I don't know. I know about confirmation 1 year, but I don't know about the actual application.
There is no limitation. So people usually die even they stay 20 years before they start the process. There is no limitation. So Mr. Canning died in September 2021 from respiratory complication arising from COVID-19. He was survived by 2 daughters who had never visited Kenya and no interest in the property in Kenya. Mr. Canning left a will that was subjected to probate in London in United Kingdom. In that will, he bequeathed 2 properties to Stanley. Stanley was contacted through his local chief and put in contact with Mr. Robinson, the solicitor handling the distribution of Mr. Khan estate. He was informed of passing of his boss and wished to express his wills in his will. He was instructed to come to your chambers to receive further advice on how to obtain his inheritance. Advice tendered on how he will obtain his inheritance. 4 marks. What do you think?
So this question is testing on resealing of foreign grants. And this is provided for in the Law of Succession Act under Section 77.
Mm-hmm.
It's also provided for in the Probate and Administration Rules under 52.
Mm-hmm.
So the application can be done by way of petition, either by the person, in this case Stanley,
Mm-hmm.
or he can get an advocate to do it in his place.
Mm-hmm.
And the advocate or the petitioner himself has to lodge the application in prescribed form supported by an affidavit,
Mm-hmm.
and next to the application, a certified copy of the grant issued in the foreign country.
Mm-hmm.
Yes.
Okay, that is true. You can see what the best performing student had to say on this question. He did it as last. If you can add something, and then I'm going to add some things here and there related to this question. Section 4 of Law of Succession Act provides that in determining the applicability law of succession of immovable properties, the choice of law would be where the property is situated. In the present scenario, the subject matter of will is immovable property that is in Kenya. So that is very, very important. The immovable properties is in Kenya. So it determines law that they applies laws of Kenya. So the process of receiving, you have discussed it well. You need a case law on receiving, where a receiving of grant was issued. It is one of the pending case law I'm still finding. There's another question that asked about this part in the past, and I needed a case law I've never found. So if you get a case law, in your comments there at the website, you can put a case law on where a grant issued in a foreign country was received in Kenya. I need a case law. You have one, Marianne? Hello?
Yeah, now I can hear you. I'd lost you for a minute.
I'm saying, do you have a case where a receiving of grant was issued?
I do not, because even the one that is here is, no, it's not useful. It's about that an administrator can be brought against administration. Oh, no, it's about an administrator, so it's not helpful.
So we need to I need a case law on that. So if you get a case law, you can share. You need to know how to draft this receiving. It has been tested as zero question. It has not been tested on drafting. I suspect it has come as a drafting question this November, this November exams. Please practice on how to draft this application. Of course, you have already practiced and you send me the question. You are not looking at them, but I'm just reiterating.
I have a question, Mwalimu. In the question, we've been told that the will has already been probated in London. So why is the best of being asked for that they should apply for a grant of probate again?
Because it is how foreign judgment are you see, in that act of recognizing foreign judgment, usually foreign judgment given by a common country, it usually come here and recognize. For example, you find a case, a divorce is given in UK, that decree even distributing, saying that the properties, how they are going to be shared by the divorced couples. The properties are in care. You cannot come directly and start applying doing. It needs to be recognized by the Kenyan courts. So this is a procedure that is given in our laws, that laws as succession act. So after a foreign grant is given, it is recognized by Kenyan court so that it can have effect. Are we together?
Yes, we're together.
Yeah, and of course you can be asked. I think there is a Q&A where it is asked. I think you have made me to remember. There is a question that is asked that someone has a property in UK and he died in Kenya. And the question was asking you, asking this person want to get the properties in UK. Of course, you say that first of all you get a grant here. No, he will get a grant here in Kenya, and then you go to the UK for it to be recognized there. And I remember I was even researching the UK law to see the relevant law there. It is there in the Q&A. It was asked. Sawa.
Yes, Mwalimu.
It is there. It is very, very important. You look at that because it is now Natoki, the property is in UK, but the person is here. But this question is asking a person is a UK citizen, but has an involvable properties. It is opposite of this. Very, very important. It can be repeated again. And it came, I remember I was researching even for the UK law. To see the relevant law on grant of probate. So we go to the next question. The next question is question 5. 5 and 6, we are going to deal with them the minutes that are remaining. Major Austin urgently sent on US peacekeeping mission in Republic of Wakanda. Just before leaving, he told his fiancé, Harrison, in presence of brother and cousin, if I die in war, all my other possessions shall belong to you, Harrison. So every time you see someone has been sent to go to war, just know that these are soldiers, and they say something. It is usually the question is asking you on privilege use and the requirement. Major Astin served his time in war and returned back after 1 year. 2 weeks after returning, he was involved in a serious road accident and died. Harrison is the serious of taking out a probate. Harrison, of course, is the wife. The reason of taking out probate based on the oral will of the deceased and has approached you for advice. In light of the narrative, interrogates the will by Major Austin and whether it is valid. So, what do you think, Marianne?
So, as you've said, this is a privileged will. It's governed by Section 9 of the Law of Succession Act, and it provides that for persons in active service, like in armed forces and the merchant marine. So, for the will to be valid, it has to be privileged wills are an exemption to oral wills, and in that as long as they remain active, as long as the person remains in active service.
Yes.
And it really has to be done in the presence of two witnesses.
Yes.
So there are very many cases on it. For instance, Gathward versus Kane, and then there's the other one, Rewingham. And in all of those, found to be valid so long as they were made by a person in active service.
It's
In
very
this
hard.
situation, yes,
It's very hard to find a Kenyan case on that. You know that, of course. The probability of such kind of a scenario happening in Kenya is very difficult. You know that.
yeah.
So it's very hard to find a Kenyan case on this.
Yes.
Sawa, continue.
In this specific case, Major Austin survived the war, and he came back and died 1 year later. So during this 1 year, he was not in active service, and he died in a car accident. So for this reason, I do not think this will is valid. And so the estate of Major Austin should be administered under the laws of intestacy. Yes.
Okay. Yes. So, of course, how do you go about getting a letter of administration intestacy? Where intestacy letters of administration, where intestacy rules apply, the process.
Sorry, Mwalimu, you are breaking. I couldn't hear what you asked.
I'm saying,
yes.
How do you go about getting a letters of administration where intestacy rules applies?
You apply for letters of administration and in prescribed form, of course, with a supporting affidavit. And I know it's governed by between section 35 to section 40. So it depends on the one that applies in that situation. Yes.
When you ask about letters of administration intestate, very, very important, petition and affidavit, affidavit of means, affidavit of justification of proposed sureties, guarantee of personals sureties, death certificate. So, of course, is a wife. We are not told about children, and the grant to be given to her without much problem because there are no other beneficiaries. It's good to know the process, how to draft. You need to practice. It can come as a question. It comes many times. Section 298 of the KDF Act. It talks about privilege wills. It's good to look at it. KDF Act, Kenya Defense Forces Act. Of course, you need a case law where another will failed and intestacy rules applied. And I think I have a case law there. But let's first of all look at section 298 of the KDF Act. 298. You can open on your side if you can. 298. 298. I can share. So your screen is loading. Let's wait for it to load. So you can see my screen, Mberian.
Yes, I can.
So section 298 says, if a member of defense forces dies without leaving a valid will, the paymaster or any officer having charge or control of any pay, accumulation of pay, allowance, gratuity, other months of immovable, to member shall pay to deliver to the personal representative, or failing that to the public curiosity to cover a copy of record specific. So this section says that all the benefits that accrue to the member of Kenya Defense Forces are given to the personal representative. So of course it is after being given the grant. So it's a section you need to have in mind where there is a privilege will, where soldiers are involved. Are we together?
Yes, we are, Mwalimu.
So there is another case. There is a case here. I want us to look at it. The case is, your screen is loading. The case is in the estate of Agnes Nyambura Gedeji. So the applicant brought before the court a petition for proof of oral will. The application was for proof oral will. So this was the mother. The mother died. So the guy was alleging that the mother was give an oral will, or the mother Agnes who died on left oral will in regard for distribution of the estate. On the evidence, after most special made reference to Pro 65 Kitengela. So he was getting that that process was given to him through an oral will. So the courts analyzed on the oral will. And there's cases there. And So the court says that it did not meet the threshold of an oral will, and it was not allowed. So of course the rules of intestacy were to apply, and the reason that the court gave was that there was like a coercion. The person took advantage when the mother was on the bed. So it's a good case where oral will failed, and it can be used in an exams. Are we together, Marianne?
Yes, we are.
So that's a case you need to note for upcoming exam. You can read more. We go to the next question. The next question is of course, you can be asked a question on to take a grant when the person has left an oral will. You need to know that process. So we can go to the next question. I want to share the question. Your screen is loading. So Abba made a will. Let's wait for the screen to load. Let me get some water. You can see my screen.
Yes, I can.
Abby made a will one day. She got into a fight with one of the beneficiaries and tore a will with the 4 pieces. A day later, after coming down, she put the pieces together using a sellotape. In the light of above, would you consider Abby's will revocation or not? Explain your answer.
So the Law of Succession Act recognizes revocation under sections 18 and 19. It applies for 3 ways: express revocation, implied revocation, or involuntary revocation by operation of law. In this case, we're looking at express revocation under section 18(1). And the case law to look at is Cheese versus Lovejoy and Henry versus Jones, which provide that for there to be revocation or of a will, there has to be the actual destruction of the will and the intention to revoke the will itself. And the revocation needs to be done either by the testator himself or at the direction of the testator, like in Jill versus Jill. So in this specific case, the testator, which is Anne, actually did actual destruction of the will by tearing it up. But then the following day, she put the pieces back together using sellotape. So this shows that despite the actual destruction, there was no intention to destroy the will. So there was no revocation of the will. The will applies as the will is still operational as was held in Cheese versus Lovejoy.
Sawa. Well answer. Well answered. No procedures there, no drafting. You can look at the best performing student. And there is anything we can add. Those case law are there, very, very important English case law. It's not hard, it's very hard to get such kind of things happening in Kenya. So we rely mostly on English case law. Question 5, we did it at the second. Section 17. Talks about provide that section 17 of the act that the testator may revoke his will, provided he has a capacity. Section 18 and provides for the ways of revoking. So, and I think you have discussed this, and it's okay. This question was last tested in question 3, November 2023. Another very, very important case law is Park versus Park, which had the same scenario. And the court found that the will was not revoked. That is discussed in what Q&A, year 2008 to 2019, page 133. Yes. So we can go to the last question of the day. Question 6. And I'm going to read it. Amaria died in a fatal road accident. She had various properties and also owned a bus in transport industry. She is survived by a son, Rick, and a minor daughter, Becky. Her son, Rick, is faced with the following. The rental property is going to waste as the tenants are not remitting rent to him. The bus workers are not sending their daily income from the business buses. The younger sister is bound to be chased away from the international schools she attends for lack of fees. So this question, he needs to pursue a claim for damages arising from out of road accident. In light of the narrative, advise Rick on the various types of grants to be petitioned for the respect of issues is facing. Marianne?
So limited grants are provided for under Section 54. In the first situation, he is trying to collect rent, and the appropriate limited grant in that situation is ad colligenda bona, which will allow him to collect rent and preserve for the collection and preservation of the estate. Then the second situation is where the younger sister is about to be kicked out of school because of lack of school fees. So in that situation, it will be the special limited grant, which is usually granted for a special purpose and for a limited period. And then the third one is to claim damages, which should be, we will do an grant ad litem so that he may substituted as the personal representative and sue for the damages to be gathered in the suit for the car accident.
Sawa sawa. So that is very, very important. The question was testing unlimited grant. And I think I saw very good answers by this student who did this question as the first. So Ariko Jabona is under section 67 and rule 33 to prevent the estate from going to waste. Special limited for the school fees, then granted treat them so that you can sue. As is in the fifth schedule. How do you do this grant? How do you the documents and the procedures? Miriam? You can start
all
with
of them. Okay. When we were learning this unit, our lecturer gave us like the specific one. You just alter. Let me see. It's a specific summons. She said we just alter and just make it suit the case, whatever you're asking for. I don't know why I'm not seeing it. Unfortunately, I'm not seeing it. I don't know why. Be here. I cannot find it, but I think basically most of them are issued under the section 54 or the fifth schedule of the Act, and they're usually in the form of a petition. So you just you can support it with a supporting affidavit, but now you just edit. There's one that Madam Anastasia had said you use as the basis, and then you just edit for your purposes.
Yes. So that is very, very correct. You need to edit and know the contents that you are going to put there on. For example, this is a grant for letters ad litem. You can see in your screen.
Yes, I can.
Support for citation of letters ad litem. It is in the notes area. You can look at it again. So in the Republic of Kenya, High Court of Kenya, of course, it can be in the magistrate court, depending on the pecuniary. In the matter of course, every time someone has died, you say in the matter of estate of that person, petition for letters administration ad litem. So it is here. So you start the person who are administrator. PO Box Nairobi hereby petition this honorable court for grant of letters administration ad litem for the estate of the named person died on this day, limited in filing suit for personal representative with the power to distribute of the estate, and say as follows. We present this petition our capacity. You say the capacity and you are in, wife and son of the deceased respectively. The grant of administrative ad litem is to do issue limited for the purposes of filing. Again, as you say, why you are asking for, of course, here is for intermediary. Johnny, one of the brothers, were in the funeral arrangement of this, we are going on, drove off with one of this motor vehicle. So you say here, because of, you want to sue because of this accident that have passed, then you finish by that we have powers to dispute the estate, dated, signed by, in the presence of drone and file. Then you got to do the supporting affidavit. That one, I don't know, you have a problem. And I said you annex the annexures if they are there in an exams. And of course, in a probate exams, you annex their certificate and give the story. Are we together?
Yes, we are together.
So you need to know to draft this. Question 5 was asking on article gender bona. Look at it. Drafting grant antecedent was tested in question 2, July 2016. The question that have not been tested here, it is the one limited for to Nini to get permission to pay the school fees of a child. And I think the projects in KSL and so many drafts are there on this. I think you can get Sidio.
Yes, I actually drafted it already.
Yeah, so okay, yeah. So these are very possible questions that can come. So it is good you someone's become familiar with that. So we go to a case on grant term. There is a case on article gender bona on the Q&A question 5. That one I've told you. A case on grant and deritem, which you can use. I was trying to find online. If you can say there in comment section of the in YouTube if you have a case. You have a case, Marianne?
No, I didn't bother. There are too many limited grants.
Specifically for swing and for swing.
I don't have for any.
Yeah, so it is very, very important to look for a case for somewhere who was Nini. You can be told he petitioned the court for Nini, and then you have a case. It's very, very important to have a case. Please look at a case. I think you can find that Kenya Law website. People usually do those things. I did some research, but because of time, I did not. I did not because research you do, advanced research you do, this research you do that. It takes time. But when I'm uploading this Q&A, of course, I will have a case law. It is very, very important. So, Mr. Mali, the last question, Mr. Mali died tested. In his will, he appointed his sister Maliwaza to be the executor of the will. He was a widow. He was a widower with 3 grown-up children. 3 years down the line, Maliwaza had not taken steps to start the succession process, though he kept saying he would do so and there was no hurry. She was collecting rent from one of the deceased property and left that if she took out probate. She would not be able to continue enjoying the rental proceeds as the will divided his properties equally among all the children. It's now 4 years past their father's death, and the children are tired of waiting for Maliwaza to apply for grant. They have visited the office for legal advice. Advise the children on what steps they need. They are needed words to compel Maliwaza to take up the grant. So what do you think?
So this is citation.
Yes.
It's provided for under the probate rules, probate and administration rules. I just don't know which one. So okay, there are quite a few types of procedure of citations. The most common ones are the citation to accept grant, citation to take out probate, and citation to propound the will. But there are others that could be.
The one relevant to this question.
The one relevant to this question is the citation to take out probate. And this occurs where the citation to take out probate, I think. Okay, no. Yeah, because she's been intermeddling with the estate without having taken out the proper grant.
Yes, there's
so
a will.
In this, yes, there's a will, and then she's already started executing, but then like she has not taken out grant to confirm like her position to take out the grant. I mean to take to do the execution. So the application is done in the prescribed form, plus a supporting affidavit with the registrar. Then the registrar files a copy with the registrar and serves the citee, who in this case is Maliwaza. And then the citee is required to enter appearance within 15 days in the form by the registrar. And if the citee does not enter appearance, the citer may apply, may petition the court for grant themselves.
Yes, so this is citation. The question was limited on the compel Maliwaza to take out the grant, but of course the question can also ask you to what we dealt with the question before. The Maliwaza can be told to account to make good the loss he has made for taking the rent. So citation has been asked very many times. In fact, it has been asked April 2022 and June 2021. There are three types of citation. Citation when there is a will, a citation where there is no will, and citation creditors. I think one of the question was creditors, where someone has not, they were creditors. So you need to know, of course, it is just the same format. You just adjust here and there. It is called citation to accept or refuse probate, where there is a will. The next is called where there is no will, citation to accept or refuse to letters of administration attested. Then the last one on creditors is citation by creditors, where the deceased has no known relatives. When the disease has no known relatives. When where they are known relatives. Of course, they can do when. Of course, the creditor can do that when the unknown relatives and the person has refused to take, whether there is a will or where there is no will. Use citation to accept or refuse probate, citation to accept or refuse status or administration attested. But this one, 183, is when there is no known relatives. And I'm just thinking in my head, when someone, you can be asking a question in a scenario whereby they are creditors to the estate. Someone but they have not been mentioned anywhere by the petition for grant by the administrator. As a creditor, what do you do, Marianne?
As if okay, the creditor can either okay, that's a difficult question. I know there's citation by a creditor. If others have refused to take out the ground, you can cite them, or you can if they do not if they still refuse to enter appearance and take out grants, then you can apply. I think there's a specific petition that can be done by a creditor of the estate.
Yes, where they have completed refused. But first of all, is a citation. But I'm asking you, in fact, this is a very common question, where they have not been mentioned by the petition. For example, letters of administration. They have not been mentioned by the administrators. And you know the person owed you a debt. What do you do as a creditor?
I think again it will depend on the stage at which the probate procedure is at. If they've just applied and it's been gazetted, you can object.
Yes.
If it's after that period but before confirmation, you may protest. And then if it's after, you may apply for revocation.
Very good. That is the answer. That is the answer. So that is the answer. And know how you do an objection application. Very, very important. A protest, you must know how to draw it. And of course, revocation, we have discussed so much. You need to know how you are supposed to do. That is a very possible question. And we have come to the end of the class. I hope it was, and you can get a case on especially creditors who were not mentioned by the administrators. Those cases are very, 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 very common. And you can get a case law for that's a possible question for the upcoming exams. So we have come to the end of our class today. It was very long. Next class is on Saturday, 6 to 9 p.m., where we are going to discuss the March 2022 paper, 2023 paper. And I think by these recordings, the people will be ready for the exams. Yes.